Let's get started then.
Okay. You're good.
Excellent, thank you. So good afternoon. This is a convening of Massachusetts Gaming Commission. We are continuing a conversation from yesterday. This is a virtual meeting, so I'll take a roll call. Good afternoon, Commissioner O'Brien, and I love your chair.
Commissioner Hill and I are of the same mind. I am here.
Excellent. And I like the V-neck on you. I've been wondering about the V-neck. There we go.
Yep.
Excellent. Commissioner Hill.
Good afternoon. I am here. You look better in yours than I do mine. Let me just say that.
You look far more official than I do, especially with the turtleneck.
There we go. And then we have Commissioner Skinner.
Good afternoon.
And Commissioner Maynard.
Good afternoon.
And we'll officially call to order public meeting number 440. Today is March 2nd. And before we continue, I want to have Commissioner O'Brien and Commissioner Hill explain the shirts that they're wearing today.
So it's National Problem Gaming Awareness Month. So probably should have done it yesterday, but figured we would do the Game Sense t-shirts showing solidarity. And true confessions, I can't remember the numbers that are on my sleeve. I know Commissioner Hill has a much better memory for it.
421.
421, yep.
Yep, the 421 is on the back, and we have the 1-800 game line. So for those who need some help, 1-800-GAM-1234 will get you some assistance. This is our new uniform for those that are at Game Sense, and as people already know, they're right in our casinos, and they're there to help anybody who may need some help in regards to problem gaming. And yes, yesterday was the kickoff of the month, and today we do show our solidarity with this division of our commission, and proudly wearing it today.
Excellent. And the 421, I know Mark is there, but it's up to 4 days a month, right, Mark?
Mm-hmm.
No more than 2 types of gaming.
Correct.
And no more than 1%
Of income. Right.
Right?
Yeah. Thank you all. I really appreciate that. It's really touching. National Problem Gambling Awareness Month is an important event that the commission has marked now for a number of years, for every year that we've been around. And you know, it's a good reminder that we do need to pay attention to gambling related harms. This commission does pay attention to gambling related harms. You see it woven throughout our mission, our regulations, our statutory obligations. And so thank you so much for wearing that. I appreciate it. I'm really touched.
Yeah. And it's designed by Game Sense. Those shirts were designed by a Game Sense advisor. And of course they reflect the new entree of sports wagering. So, all right. And Mark, a reminder that the Gaming Commission has adopted voluntary self-exclusion for sports wagering as well, right out as we approach the March 10th launch date. So thank you to your division, Mark, and I know that your team is hard at work, so thank you so much.
They really are. Thank you.
All right, so we get started returning to the conversation that we were having yesterday, and I'll just remind folks, there was a motion, and Commissioner Skinner, thank you so much. She moved, and I'll turn to her next. She had made a motion, and she was kind enough to withdraw because I had a practical question around whether there would be any implications for either the third-party affiliate, the advertising and marketing industry, or our operators. And so you withdrew your motion, Commissioner Skinner, and I appreciate that. It was a complete practical question. And I asked Secretary Director Wells if she could reach out to the operators. And in turn, I did hear back from Mr. Ikra, who was on our roundtable, who represents the third parties that third-party affiliates that were in front of us at our roundtable on Monday, that is Collective USA, Katina Media, and GDC America. And he submitted a letter. So I'll turn to Commissioner Skinner first to just remind folks of the motion that you had made, and that will give us the context. And again, I want to thank you for that flexibility, Commissioner Skinner, yesterday.
Absolutely. Thank you, Madam Chair. Okay, I move that in accordance with.
Actually, before we actually do the motion itself.
Oh, this is just to repeat what she said.
Right, because I did want to speak on one of the questions, and particularly Commissioner Skinner, you had it yesterday, and I just wanted to make that information clear before we move into motions.
Oh, no, can I just, before we move, I guess not, I want to be clear, Commissioner Skinner, I was just asking if you could remind everyone what you did move.
Oh,
yesterday.
and not read the actual.
Not to read the move, yeah,
Okay.
so that then we'll have our fulsome discussion. If you don't, I just want to make sure everybody knows where we left, because you were very kind to withdraw just at that moment. So thank you.
Thank you. That's clearer. So after lengthy discussion, I am of the mind that with respect to the regulations 205 CMR 256, we should, as a commission, and when we take a vote, we will determine whether you all are in agreement, but offer a waiver, the opportunity for a waiver to all of the sports wagering operators and marketing affiliates with respect to the CPA agreements, as well as the revenue share agreements. So essentially, the motion that I had put forth yesterday would keep the language as is in the regulations 256, but it would offer the opportunity for a waiver to be granted to individuals who are intending to enter into either one of those agreements relative to marketing.
And I think you had a deadline in mind that the waiver would sunset at a certain time.
April 14th, as I understand it, and that date was given to us by our legal counsel. I understand that there is some filing with the Secretary of the Commonwealth's office that might be tied to that date.
And it was that deadline that prompted me to say, I wonder if that affects their contractual arrangements at all. It was strictly a practical question, and that's where we had I asked Secretary Director Wells for some input. Before I turn to you, Commissioner O'Brien, I'm going to ask if Secretary Director Wells could update us on her.
Thank you, Madam Chair. So I did reach out to all the operators. I did get some response. Obviously, it was late in the day when I was able to send that out yesterday. But as far as the responses I got, I won't be specific to each of the operators. Just I'm not sure if there's any potential competitively sensitive information on the association, but two of the operators indicated they wouldn't be using affiliates, so it was irrelevant to them. One of them indicated that it would be disruptive to do this now. Another indicated that it would be actually helpful to do the waiver. And then a third, although they do use affiliates, they only use two, and they said they were neutral. It really didn't make any operational difference to them one way or the other.
Thank you. And then from
There's one more, pardon me, there's one more that's not launching right on next Friday, but that's one of the ones that said they have no affiliates, just to make sure that's clear.
okay, excellent. And then from Mr. Ifra, who again, he participated in our roundtable, and we thank him and his colleagues for helping us understand the industry a bit better. He did indicate, and we made sure that the commissioners have a copy of this letter, that they would support the waiver, that it's essential. It would be the waiver, as Commissioner Skinner said, for both the CPA and revenue share at this time. And that in terms of the deadline, that they would be able to have no problem amending the agreements if additional guardrails were put in place at the time of April 14th. And that was really my very, very basic practical question. It might be the lawyer in me, but I just wanted to make sure we didn't create some kind of a practical problem. So with that, we've got a little bit of, sounds like a little bit of input from all directions, from executive director roles in from the affiliates themselves. So before we go on, I know Commissioner O'Brien, you're eager to contribute, so let's hear from you, and then we'll go around the commissioners.
Sure. Thank you. That's actually helpful to me in terms of I am still of the mind of I'm not convinced on revenue share. And I wanted to speak a little bit more as to why. I was trying to inform myself about the push versus the pull and got a little more of an education on CPM and CPC, cost per thousand imprints and cost per clicks, which is the push saturation advertising. And I reached out to Brianne and said, am I correct that the cost per acquisition model would have a deterrent effect on that type of push marketing? And in her opinion, that was an accurate statement. Not necessarily the same can be said of the revenue share. And again, looking at other states, like again, New York moving in our direction, and we're contemplating moving away. I'm not convinced that we should be dropping the ban on that, but I absolutely don't think there's reason in the next 5 weeks to do it, given that's not really going to necessarily have the impact we're looking for on the push marketing. For what it's worth, also from a research perspective and a controlled entry perspective, we're coming up with the research and responsible gaming research agenda. And to me, if we did anything, it would be only to do the cost per acquisition model. And then we have the ability to see, is it really doing what we wanted it to do, which is driving down the push marketing and doing what we thought it was going to do. And so to introduce both, to me, actually loses a research opportunity for us as an agency to see what is the real impact of the method of advertising and affiliates. In terms of the information, Madam Chair, that Karen just gave us for the operator's perspective on this, with all due deference to the perspective of the affiliates, my job isn't to make the affiliates money. My job is to maximize the profit and minimize the risk in the Commonwealth. And you've got operators who are saying they're either not using it or in equal measure saying it's helpful and disruptive. Given that, I'm of the mind that there's no reason to do this in the next 5 weeks. I think we should leave the ban where it is. But to the extent this commission as a body or as a majority is moving toward considering a waiver, I would strongly urge it to restrict to the cost per acquisition only. I don't see the reason in the next 5 weeks to be putting a waiver out there on a rev share model, where that's where I think the stat that I was given, in the UK, something like, 90% of the money comes from 5% of the players, which to me is probably a pool of, big players and people who are addicted and shouldn't be playing. So that's where I'm coming from in terms of when we closed yesterday and as we sit here today. That's the information I got and the posture that I'm in right now.
Thank you, Commissioner O'Brien. Somebody else want to lean in right now? I think I'll put this out for discussion. If I recall correctly, we heard from the gaming associates, and that was Kevin Garnett. Mr. Garnett was kind enough to submit a letter to the Gaming Commission representing the Gaming Society, and then we had the co-founder, Ms. Messler, who actually served on the roundtable for us, and we appreciate very much their voice. It's my understanding that the rev share comes into consideration, maybe more so for smaller operators and smaller companies, and that might include MVEs. When we were putting together the roundtable, I thought it was important to have the voices of the smaller affiliates, and I did mention that I really wanted some diverse representation. And we heard from them, and I think, and I can be corrected here by anybody, that the rev share might be applying to those who are newer to the market, because they have not yet formed enough of a experience in business to be able to really thrive with just the CPA. Does that ring true to anyone else, or am I making that up?
No, that's my memory of the conversation.
Okay. So,
I would point out
well,
Better
that's why-
Collective is commented that they want to shift toward rev share in the States. So I found that a little strange that I think there's a bunch of different people that use rev share, but the representation that newer entrants into the market would be more able to do that than
the CPA.
CPA. That's my memory of the conversation.
Yeah, that was mine. So that's why yesterday I kind of led with, I understand that. I think Commissioner O'Brien just mentioned like 90% of the marketing affiliates rely on CPA. That's why I thought if there's any concern about, revenue sharing, that we might look at the other states' practice where the heightened licensure offsets concern. Anyway, I turn Commissioner Maynard, Commissioner Hill, Commissioner Skinner. I just wanted to throw out that competing piece in my mind to what Commissioner O'Brien is saying. Commissioner Maynard.
Madam Chair, thank you. I think Mr. Garnett, his letter and his associate coming to the roundtable and making a real push for folks who weren't initially in the industry or entering the industry. And that was really informative to me. On top of that, I share Commissioner O'Brien's general worry, and I do think, and we did mention this yesterday in the conversation, that I would be totally supportive of a heightened licensure model and a heightened model that made sure that we got the information that we need. I did talk to Director Vanderlinden last night briefly about some of the issues that can come with both models and how the push does relate to the pull and vice versa. And so I think where I would come on this is, I hear what Commissioner O'Brien is saying about New York. I've also been told by a few of the team members that Connecticut may be going the other way, at least looking at softening. So, I think that a lot of people are still trying to figure this out. They're trying to figure out where to land. I would take an approach that was somewhere in between, where you had a heightened licensure for the revenue sharing, but that on the cost per acquisition model, we let it play out. And then we adjust as we get more information. And I think that Mark and his team, and we talked about this last night too, we'll get a lot of information in the next 6 months to a year to 2 years. And we've been nimble and we've been willing to adjust. And so that's how I would kind of look at this.
Commissioner Skinner.
I'm thinking similarly to Commissioner Maynard. The only thing that's changed really for me between yesterday and today is like you, Madam Chair, I feel a lot better about the proposal that was on the table via the motion yesterday in terms of impact to the affiliates and the operators. In addition to that, I am more comfortable coming to the conclusion that the heightened licensure for revenue share agreements, marketing affiliates who utilize the revenue share arrangement, I'm of the mind that there should be a heightened level of licensure. And I understand that as we move through 234, whether that's today or in the coming weeks, prior to April 14th, that we may very well do that and also implement additional guardrails to address some of the concerns, particularly Commissioner O'Brien's concerns that I think we might all share. So I'm going to stick with my position, the position that I made clear yesterday, again, with just a more definitive opinion as to whether or not there should be a heightened level of licensure applied to the marketing affiliates engaging in revenue share. I still feel like there is a lot of information that needs to be uncovered relative to the push aspect of revenue share. A question that I have that's still outstanding is, are there marketing affiliates who engage in push advertising rather than the pull. If that's, I want to explore, I just want to explore that a little bit more in terms of really understanding who we're targeting here in our regulations as they're currently written.
And so by a waiver through the April 14th date, now that we're hearing kind of a neutral response on impact, we would get some data over the course of 45 days, Commissioner Skinner, that you think would be helpful for you.
I'm hoping so, yes.
Commissioner Hill.
The good thing about going last, Madam Chair, is everything has already been said that needs to be said. And I am in the corner of Commissioner Maynard and Commissioner Skinner in everything that they have said, so it doesn't need to be repeated. But I am still in the same way thinking as I was yesterday, and would move forward that way today.
So the difference I'm hearing, and I offer this as really not an indicator of my position one way or another, but the difference I'm hearing perhaps is that Commissioner Skinner is thinking of entertaining perhaps that heightened standard. Are you thinking of that for April 14th, or are you thinking of that for now, Commissioner Skinner?
I mean, this meeting is scheduled until 3. I don't know, what our legal team is prepared to respond to in terms of that discussion and the IEB team. But whether it's today or at a future meeting prior to April 14th, I think that we do need to adjust those regulations, 234 regulations that speak to vendor licensure, to account for that heightened level of licensure for marketing affiliates.
So let's, is that a good segue to turn to Director Lilios? Maybe we start with IEB and the licensing process. Does that make sense? And Commissioner Skinner? For some, yesterday, Kara did a great job updating us, but Director Lilios, maybe you've all had a chance to convene on this topic further. Any update that you want to provide with respect to, and here's Chief O'Brien now too. Good afternoon, Kara. Director Lilios.
Yes, we did get a chance to connect this morning. So I think what you're asking me, Chair, is if the waiver is allowed, now what would the licensing division's plan be? Is that what you're asking?
If I can, and Commissioner Skinner weigh in and other commissioners, but I'm thinking maybe that the first and the second, if there were consideration for heightened licensure for the those that do participate in revenue sharing, what are your thoughts about that, if any, and then how would it impact you practically?
Okay, so in terms of if there were a waiver now, Kara and her licensing team are in a position that they would be able to intake some reduced application material from the affiliates in question, because it's important that we acknowledge who they are, that they provide the attestations that have been required for other vendors who have temporary credentialing. And she would be able to accommodate that, of course, assuming the prompt participation by the companies themselves, but her team would be able to intake that and intake the appropriate attestations under the condition that there'd be continued cooperation for like administrative completeness reviews after the go live date. But she has a process that she could intake application materials from these companies. In terms of the licensure level, certainly the licensure versus the registration level licensure as part of the routine protocol We do a scoping of the company, which means that we have more look into the various entities involved, and we have the opportunity to identify those C-suite individuals involved as well. So as a routine matter, that insight is part of the routine protocol. For registration, it's very focused on the company that is directly doing business with the operator. So we do not routinely look at the corporate structure, look at the individual organizational chart. There is some discretion that we would be able to do that with a registration, but it's not part of the built-in protocol, whereas the licensing protocol, that is a built-in protocol for us. So is that helpful?
Commissioners,
What about timing? Because that's one of my other concerns, quite frankly, with rev share as opposed to just a waiver on the CPA model is, I absolutely, if that's going to go forward, we want heightened licensure on rev share. And I don't want that short circuited just because we've decided, for timing reasons to reach this today. So what timeline does that mean in terms of putting that into effect?
So for launch, we'd be relying on attestations the way we have with all the other vendors, okay? For post-launch, we can prioritize these with, we do have a more robust temporary licensing protocol that gives us a window into both the license holder entity and the individuals. We have a checklist protocol that has been very effective at red flagging issues. So we could put that into place, and my understanding is that the number of these companies would be quite limited. So I don't think we'd be inundated with a volume that would make it difficult for us to prioritize.
And can I ask what the licensing fee is? We would basically have to change the reg, right? To make reference to a particular level, right? And then what are the tiers in terms of the license and application fee that already exist?
Yeah, the existing, it's a $5,000 fee at the registrant level. And the registrants do not pay for their investigative costs. At the licensure level, it's a $15,000 fee, and they do pay the investigative fees and costs.
And do you have a ballpark on the investigations cost on the per registrant?
Again,
like who does pay for that?
It's part of, I guess, like technically I want to ask Derek, but I think it's part of the actual assessment,
So if someone doesn't use an affiliate, they're paying for the background vetting of registrants they don't use as part of the assessment?
I don't want to get over my skis with, that's my understanding. I can confirm that with our finance team.
Okay.
But we do not bill back for those registrants.
Commissioner O'Brien, could you ask your question again, please?
So my question was, with the licensing, they pay the $15,000 fee. They are also then charged for the investigative costs. For the registrants, they pay the $5,000 fee, but all of the background investigative costs, they're not charged for that, which means someone else has to pay. And we're looking for confirmation from Derek, but Loretta's understanding is those would then be divided amongst the licensees and levied as part of the
Assessment.
blanket on the assessment that they would get. So you have two licensees coming forward saying, we don't use affiliates, but under that process, I'm just realizing they're going to get billed as part of an assessment for clearing third-party market affiliate registrants that they don't use. So I'm curious about that part of it, because another deterrent, quite frankly, in fly-by-night operators may be to say, we're going to charge you for the investigative costs on registrants for the affiliates.
But it may,
Though it would only be over the 5,000 that would
it's
be,
over the,
right? So if the investigation
Right.
costs $4,999, there's no impact to the other operators. And if it costs less than the 5,000, then
That goes into a pool.
plus, right, impacts the ones that don't use them.
Kara, do you want to weigh in at all?
I think, you know, Loretta and I, as she indicated earlier, touched base on this, and I think, you know, having, you know, whatever the path forward is, where, you know, the licensing division is ready to intake as necessary.
Director Lilias, I don't want to be on the spot because I don't know the answer to this question, and it's okay if you just haven't, but did you have the opportunity to speak with any other jurisdiction that does look at this from a heightened licensure?
Yes, we do. We did. Our team met with a few other jurisdictions. And yes, we are aware of other jurisdictions that do divide it up into a couple, and I think at least one jurisdiction has several different levels. And another jurisdiction does all at the registrant level. And largely it was based on perceived risk of, you know, that around RG type issues and vulnerable population type issues. You know, that's, so yes, we have done that. We have spoken to them about the types of things they look for in their investigations that they find helpful. So we feel from an investigative point of view that we could hit the ground running, you know, with fine tuning our protocol, knowing that we're constantly, you know, adjusting where necessary. But we feel like we got some input from a few other jurisdictions.
Okay, thank you for that. Commissioners, do you have questions for Director Lilios or Chief O'Brien? Okay, now we'll turn to our legal team. Paul Commoners and Caitlin Monahan and Todd Grossman. I don't know, I don't see Carrie today, but I know Mina's hanging out. Other thoughts?
We've got the whole team.
Yeah.
I think procedurally, it would make sense for the commission to make a decision on the initial question of whether there's going to be a waiver for the CPAs and or rev sharing. And once that decision is made, we can move over into the vendor reg and look at that language, because the vendor reg language is contingent on that initial decision.
Right. So have you any thoughts on, you've heard the various policy discussion. Do you have any thoughts in terms of the implications for the industry?
Nope, just happy to help figure out how to implement whatever you would like to do.
So it does seem like we're a little inextricably intertwined here, though, because if there's a vote to say waiver without the amendments to the reg simultaneously about how we're going to deal with licensing, I mean, they have to be done together, really, right?
Well, I think let's take it sort of one step, because we don't necessarily have to have a vote. We could come to a consensus on what I think Caitlin is saying, the initial policy discussion. And then we could move to the vendor discussion, and then we could go back to the actual vote.
I could even say one other thing, Chair. I apologize. I didn't mean to cut you off. You could vote on the vendor reg, and you could include a higher level of registration for rev sharing. And then whether or not you decide to allow rev sharing, fine. If you don't allow it, then that part of the vendor reg you just aren't using at the moment. That's one way to do it too.
I kind of feel like we're all just sitting here together. So the process, I think we're going to work it out all right. With just some sort of taking the temperature. So let's go back to yesterday's packet includes Mr. Garnett's letter. I just wanted to make sure everybody knew that that was available. I referenced it, and I wanted to make sure it was on. I don't know which page I'm looking at. an older one. And then the letter that, the documents that came in with respect to my inquiry around the practical implications, we can make sure those are available to the public as well, in case someone's asking for those. We'll make sure Mills get that to the public domain. Commissioner Skinner, as I started, you were the one who moved and you were kind enough to withdraw. Today, hearing today's discussion, would you want to adjust, or would you like to move on the same motion? And I deferred to you because you were moving pretty yesterday.
Well, I think if we've got consensus without a motion, I think I think that's the better way to go.
Right. So,
practically. So I don't have to renew that motion. I'm satisfied that there is a consensus. But I do think.
And I interrupt,
so
I'm not sure what the consensus is. So
okay.
So I'm wondering, is the consensus applying the waiver altogether, period, or is it an amendment to your original motion in light of what I heard? Maybe you were saying, oh, I might want to consider the heightened licensure. So I don't want to put words in your mouth. Are you thinking that you'd want to wait for that heightened licensure until the 14th, like yesterday, or do you think you'd want to adjust that?
So I'm taking 256 separate and apart from 234, with the understanding that 234 needs a bit of work, I think, to accommodate where we all are, or where the consensus is that there should be a heightened level of licensure. But the question I have relative to 234, before we deal with 256 and you get the answer that you're looking for.
Yeah, and I think it's okay for us to do both.
Yeah, what's the status of those regulations now? They're not in effect by emergency, is that right?
No, it is. So
It is,
234
okay.
was like the second reg the commission took up. So it's fully in effect. So to the extent you would like to take action on it today, you would be moving forward on an amendment to it.
An amendment. Yeah, so yeah.
Okay.
Which could be done by emergency, right?
Correct. And if you wanted it in effect now, you would have to do it by emergency.
Right.
Okay.
So if we wanted it to apply to launch, we would do it by emergency.
Correct.
Okay, and that explains the language in the motion for 234, which I was just getting a little bit stumped on.
Of course,
Okay, so thank you.
Of course, I'm not looking at the motion, everyone. So if you could send the motion to my top of my email box, because if that's the guide I need to be, I'm hoping for a genuine policy discussion among us. So go ahead.
Yeah, no, relative to 256, I do think Commissioner O'Brien's right. They're intertwined. So I want to make sure that we're all comfortable, with the consensus that, as I understand it, which is to offer a waiver for both CPA and revenue share. And parallel to that, come up with language in 234 that addresses the higher level of licensure for revenue share. So I don't know how we accomplish that, what the best way to accomplish that would be, but I do think they're hand in hand.
So, okay, so that's really helpful. So now.
Could I clarify that consensus, please, just so that it's clear on the record? We're not taking a vote, but just so we're clear, if we're going to have rev share, like I said before, I absolutely am in agreement that there should be the heightened licensure requirements for it. So if we're going in that direction in the amendment, I'm absolutely for that. But just so we're clear, I think it should be done in the normal course. I don't think we should be giving waivers on the rev share right now. So just so the consensus is clear on the record,
Right.
that I'm not in agreement on the rev share at all.
I
understand that. And I think that, that would mean if we did not include revenue share in the waiver, that would mean that from March 10th, the March 10th launch, those smaller businesses would not be able to engage with the sports waiting operators.
Well,
That's
they're
the only
theoretical.
concern
We
that-
don't know if that actually applies to anybody who's in the queue. We don't know.
I thought that I was just gonna say, I thought that the participant on Monday at the roundtable, we had at least one.
Well, they said it would be
fall within
difficult, but
that
I didn't know
category.
that they were actually
You
in
know
the
what,
queue.
I'm
ready to
gonna just
go.
ask for a little order, everyone. Everyone's just slow it down a bit. So, because I want to have everyone finish their thoughts. Commissioner Skinner, then I'll turn to Commissioner O'Brien. Commissioner Skinner.
I was just trying to confirm my recollection, and I think someone did that. I see Commissioner Mader nodding. Is that the participant on Monday was an entity or vendor that utilized the revenue share agreement. So I am under the impression that there's at least one of those entities that will be impacted should we not lift the waiver across the board. But I think Commissioner O'Brien had a different take.
Well, because I don't think anybody has those affiliate agreements yet because they're not lawful in the Commonwealth. So right now, nobody falls in that category. There could be the potential that the individual from the company on Monday becomes that individual. But right now, it's not like there's somebody with paperwork in at IEB that would require us to act today for us to flip a switch. Now, they may very well get their paperwork in if rev share is allowed, but it's not like there's a pile of X people who have actual signed affiliate agreements with any licensees at present under either model, because it's not allowed under the current reg.
Yeah, understood. But it's the potential deprivation of that vendor from the opportunity to join in this industry with the rest of the marketing affiliates that would concern me. If we didn't, do it across the board.
And I understood that was your position yesterday. Make sure that we weren't somehow inadvertently affecting that entry. And of course, the elevated licensure could have additional barriers, right? We're all clear on that.
Yeah.
It's just that that's a model that certainly has been adopted. I'm turning to Commissioner Hill now, and then we'll go back to Commissioner Skinner.
Chair, can I just have a follow-up before we get to Commissioner Hill? This doesn't preclude the opportunity for the commission at a later date to decide that it wanted to not have the waiver apply to the revenue share agreements, or maintain its current prohibition on those agreements. This is just kind of leveling the playing field, for all of those entities until we get a better understanding, more knowledge of the industry, and get a better understanding of how we might want to see this play out in 234.
Thank you for that. I'm turning to Commissioner Hill, and maybe you're not weighing in. I thought you would turn. Yeah.
The only thing I would add is I don't understand why we wouldn't be, I think we call it bifurcating the issue. In your motion yesterday, you included both. And what I would urge you to do today is separate the two and do two separate motions so that each commissioner would be able to vote their conscience on this moving forward. And the way I support what you have been saying, this is something we can bring back and talk about and fix as needed once we get some more information. So I'm suggesting, because there isn't a consensus on both issues, but there is on one for sure.
I clarify, when you say both issues, you're talking about CPA versus rev share?
Yes, Madam Chair, thank you. So with that said, I think it's really two different discussions, and we needed the overall discussion, but I think we've now brought it back down to, it should be two separate decisions being made so that each commissioner can vote the way they see fit on those two separate issues.
Commissioner
I would also add, you could really separate it out three different ways, right? So you could add the additional, if the rev share is passed, then you could put in the heightened licensure as a separate vote. That way, because I heard Commissioner O'Brien and what she said about if it did get through, then she would recommend the heightened licensure. I think I'm hearing that we all probably would recommend the heightened licensure. And then just another point, and something that Commissioner Skinner, I think is getting at, but I would just like to say it. If you're an operator and you're listening today, or you are an affiliate program, and you are going to engage in this rev share, don't take advantage of people. You know, do it for the reasons stated at the roundtable that we heard on Monday, which was to educate people, do those things. This commission will not tolerate, someone trying to bankrupt a consumer. And I think you're hearing it across the board here today. None of us are going to tolerate that. We will change the rules if we have to. But to keep us from doing that, period, do what you say you're going to do.
So can I add a little bit of even a nuance? It could be rev share with the height license, rev share without. I'm of course hearing Commissioner O'Brien, but I just don't want to make any assumptions here. I think there's a consensus that rev share and the height license may go hand in hand. I just don't want to make any assumptions today. Now I'm going to turn to the technical aspect of this because I can see Caitlin going, So what I'm guessing, this is my question, Caitlin. If they, and I know this is what I was struggling with yesterday, that regulations often don't come with sunset provisions. I know we have one out there and it's kind of driving me a little crazy. I can't remember which reg is out there that has a sunset.
It's the suitability. It's whether you can claim preliminary suitability and operate before you get final. We only did it for launch purposes. That will sunset in fall.
Thanks. I spoke to Commissioner O'Brien about this earlier and she did her homework for me. So thank you so much. So we do have one out there that we need to keep track of.
Mhm.
So I was, it's not ideal because I know the industry, the operators, everybody is relying on some certainty from us. But, we beg a little bit of tolerance as we work through this. And so my question is this, are you hesitant, Caitlin, to include that April 14th deadline on the vendor reg? And if we were to include a heightened standard for those third-party affiliates that engage in revenue share, that it would just be in that vendor regulation for however, until we amended it down the road. And then, but would it be okay to have the waiver with a sunset on the advertising side? Is that what you're?
Yeah. Yes. So I think you've got it exactly right. So we do the waiver on the advertising reg, which is again tied to the sort of promulgation timeline, right?
Yeah.
So you'd know for sure that you'd have the waiver at least through April 14th on advertising. On vendors, what you would say is if let's say the commission decided today to amend the vendor reg so that third-party marketing entities that conduct CPAs are registered, revenue sharing third-party marketing entities are licensed, you'd put that into effect today, you'd start the promulgation process. Remember that reg can change all the way through to the final vote. So you're going to have 3 months to make any changes for the final reg. It may require a waiver in the middle, but we have some time on the process. So I don't think there's any issue at all with doing the waiver on advertising today and taking a vote to start the promulgation process by emergency on the vendor reg. And it might be helpful when we get to the vendor reg to take a look at it. We would want to walk through that anyway, but I have no problem on process with that.
And thank you to Carrie for sending the motions to me right at the top. Thank you so much. So on the technical side, I think we can work it through. So do we have a consensus that everybody agrees, no problem with waiving the CPAs? We're all in agreement on that.
I wouldn't say no problem, but you would have an aye vote for me on that.
I should not have said it with no. Now that there's a consensus to, I should not have said that. We could waive our current reg with respect to CPA, the restriction, the prohibition on CPAs through April 14th. Is that where we have all an agreement? Am I hearing it that we would like to maybe move to Commissioner Hill's point one at a time and just deal with CPAs?
Yes.
Okay. If so, are we at a place now on respect to CPAs that we're comfortable moving, or do we need further discussion on that?
We are ready to move forward. I'm ready to move forward.
Commissioners, any other, we'll have a motion and then, and Commissioner Hill, do you mind if Commissioner Skinner moves on it first?
Oh, I was not going to move on it. I was just saying I'm ready to move if everybody else.
Okay, again, I'm appreciating of the generosity of yesterday. Thank you, Commissioner Skinner. So I think I like the idea of Commissioner Hill of just one step at a time.
Great idea. I move that in accordance with 205 CMR 202.023, the commission issue a waiver to all licensed sports wagering operators from 205 CMR 256.013 that allows cost per acquisition agreement until April 14th, 2023, as granting the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purpose of General Laws, Chapter 23N.
Second.
Thank you, Commissioner Hill. Okay, Commissioner O'Brien, any clarifier that you wish to add?
No, just that my stance on this is different because for me, my ability to inform myself is this has a positive impact on stamping out saturation and push marketing. And so for those reasons, I'm an aye on that motion.
Commissioners, I think I can speak for the rest of us that we understand the implications of the CPA as helping on the issue around frequency and intensity and push. Right, we learned that at the round table. So any other discussion? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. 5-0. So there, we took care of that piece. Now,
Does it make sense to do the heightened requirement?
well, I'm
First,
wondering, can I?
Because I
ask
think
you-
there's consensus on that in a theoretical.
I hear you. I'm wondering, isn't it okay for us to have a motion that acknowledges our policy position and then go into the two technical reg change? In other words, that the motion would.
Were we to have rev share, it would be subject to a heightened licensing requirement.
Right, because I don't want to jump to that conclusion, Commissioner O'Brien, without some process.
Mhm.
And unless we just have a strong understanding, sort of that temperature. I want to make sure I haven't jumped to any conclusions there. That at this juncture, between now and April 14th, are we all looking to increase that standard? Commissioner Skinner? Okay. And I say that with Commissioner Skinner because that wasn't her position yesterday. I don't want to jump to any conclusion. So Commissioner Hill, you were also ready to second that. I think you did yesterday. So, all right. With that said, then we can go to the technical. And I think Commissioner O'Brien has the right idea that maybe we turn to the vendor and maybe should we turn to the actual document itself, Commissioners, just as a reminder of the reg itself. If you all have it. I'd like to see what we're amending.
What page in the packet
So-
is it?
Getting it right now. Would
Okay.
you like to go through the vendor reg altogether right now, or would you just like to look at that particular section?
Are we supposed to be having that on is that on our agenda to go through the
Yes.
other changes?
Yeah.
Yes.
It's 280.
280?
Oh, I know. you've been-
234, right? 234 you're looking for?
Yeah, and I know Paul has been dying to get them in front of us, so I just wanted to make sure we're all set.
From our side, excuse me, sorry.
Because I really thought that the discussion on the agenda was limited to the intersectionality of these two. But I'm hearing that it was to update and review in totality.
And just to clarify, it's page 280 of yesterday's packet. If there's a new packet, I haven't seen it.
No, I think it's a rollover from yesterday.
Okay.
So it's that,
Yeah, I thought so, but just wanted to clarify.
Yeah, and I'm just looking at the old calendar. So I have it. I think I've got them. There weren't any new changes, right?
No.
Very,
There
all
have been
right.
any changes since what was in the packet yesterday now.
Okay. So let's just talk about the intersectionality right now on the vendor reg and the advertising and the application of the heightened standard.
Certainly. So for those purposes, I would recommend that the commissioners start on page 282. Which is where most of the work in this respect is happening. So as I said yesterday, there are three things that are really happening in this set of amendments to the regulation. The first is that we are formalizing the IAB's request previously accomplished by waiver of standards that in general third-party marketing affiliates be registered rather than licensed. The second thing is a change to the discipline regulation, which is much further down in the reg, just to bring it in line with 232, the umbrella discipline regulation. The third thing is the piece dealing with heightened licensing requirements for revenue sharing advertisers. Everything that addresses revenue sharing is in yellow highlighting on top of the track changes so that you can clearly distinguish what you would and would not be adopting in order to adopt a heightened licensing standard for revenue sharers. So the trick here is making sure that this captures all revenue shares and carving it out of the other provisions, lowering the general requirement, the general licensing requirement for marketing affiliates to registration. So what we do is we simply define a new type of service provider called a revenue sharing advertiser in subparagraph F1 as someone who either promotes or directs patrons to sports wagering on mobile applications, which is consistent with how we defined marketing affiliates earlier in the proposed amendments, or who regularly hires or recruits persons to do the same, because you want somebody who doesn't themselves run advertisements but is coordinating advertisements and sharing revenue to be required to be licensed as well. In exchange for a fee paid by the operator, pardon me, I need to tweak the language there. It should say in exchange for a percentage of net gaming revenue earned from users that the entity directs to the operator. And that language is not identical to, but is based on the definition of revenue sharing in New Jersey, in New Jersey's guidelines.
Paul, can I
Yeah.
ask you why the use of regularly in there? Regularly promotes, regularly hires, as opposed to just promotes and hires?
So regularly is in our definition of sports wagering vendor as well. To be a sports wagering vendor, you have to not only provide services that directly relate to sports wagering, but you have to do so on a regular basis. So we carried that through to the definition of marketing affiliates. We could take it out of the definition of revenue shares if you want to cover anyone who shares revenue for any length of time.
Yeah, so I guess what concerns me with the regularly in this context is it's one thing to have someone who's committed in licensing, and I'm worried about someone saying, well, I don't need to be licensed because I don't do it regularly. I'm going to do it sporadically. And so I can just be a registrant.
I do think we would read somebody who does something sporadically, but on a recurring basis to regularly provide services.
But I'm wondering what's the downside to, if regularly is removed, who do you capture that you wouldn't want to capture?
True one-offs are the people that you would additionally capture if you remove the word regularly. I would defer to the IAB on whether on whether we see those people, whether it's important to capture them, and whether the corresponding workload is reasonable.
Because to me, it's a disincentive. If you can't do it even as a one-off without being licensed, I actually feel better about rev share, right? Because then you're only going to get the people committed to the market.
I'm comfortable using regular if we've been using regular throughout as for the licensing and turning to Director Lilios.
And we have, Paul indicated that that is a term that's used in all of our gaming regs as well. I do, Commissioner O'Brien, understand what you're saying, like you don't even want the one-off. I think we use it in the gaming context to allow the companies operationally to take care of their needs. And when they have the one-offs, it doesn't make sense for us to go through the licensing process, because by the time we're, finished in taking the application and, haven't even commenced the investigation, the need has passed. So that's really why we have used that regularly term. It kind of coincides with some of the exemptions as well, to sort of let them take care of their business needs. And it's a risk-based approach to business that occurs not on a one-off kind of basis. But understand, the notation that you're using here, that, you don't even want the one-off, or you want to carry over the regularly. I think we've used it so far to allow some flexibility to the licensees to have their operational needs met.
So, but in that context, Loretta, how often are you talking about advertising and marketing versus I need maintenance, I need a slots thing, I need.
I don't think we're talking, to date, hasn't been not
advertising and marketing.
Services.
I guess that's my issue with it, is it's a completely different industry. And so I'm not so sure that regularly applies here if what we want to do is only allow rev share for committed licensed entities.
Commissioner O'Brien, the only other point that I would make is that a $15,000 licensing fee plus additional costs of investigation may set a floor on, or may already provide a substantial disincentive to engage in a revenue sharing model on a one-off basis.
But only if it applies to them. That's what I mean. It wouldn't apply to them. They would only do a 5K registrant otherwise, right? This says I'm a one-off. I don't need to.
Pardon me. Sorry, the 5K may still be a significant fee for entities that are only coming in on a one-off basis.
Yeah, I mean, I'd rather it be more, but obviously I seem to be the only one, so.
Commissioner O'Brien, I think what I hear Director Lillian says is that there's a risk-based analysis that occurs throughout our licensing process, and we allow for that one-off flexibility.
Right, but not in this venue. It's more in other purchasing, which is to me is very different than this industry and this medium, but.
Right. I'm comfortable with the consistency. Commissioners, is anybody else are you comfortable, or do you need to rework this language? Commissioner Skinner, Commissioner Hill, Commissioner Maynard?
I'm comfortable with the language, just having, enforced the regulations as chief of licensing not too long ago, or assisted in enforcing them. I understand the intent of it, and I think that IEB's rationale for not requiring licensure for this folks who don't regularly participate in these activities or this industry, it makes sense, because again, by the time the investigation is completed, the vendor will have moved on. I did have a clarifying question. If we're talking about an advertiser who does not regularly participate in the activity, and so therefore not required to hold a license, are we capturing that person through a registration? They wouldn't even be required to register, right?
I think that without changing the language.
That person would be a non-sports wagering vendor who would need to be disclosed to the IAB like any other non-sports wagering vendor.
All right.
And
so that's
licensing the IAB would have the option to upgrade them to a registrant depending on the details of the relationship and the specifics of the contract.
So is there a way to address what I'm concerned about by making the one-offs registrants?
That's what I was trying to get at.
Right.
Yes, it would take a bit of tweaking to a carve out from the so currently revenue sharing advertisers are carved out of the definition of
Register.
marketing affiliates.
Right.
So for an additional piece of background on the structure of this reg, marketing affiliates would be the only type of entity that is required to be registered in the first instance, as opposed to not required to do anything or required to be licensed, which is why if you scroll up the prior page and a half, there's a lot of infrastructure that's built out to deal with, to address the fact that we now have a type of entity that's registered in the first instance. Because we want revenue sharing advertisers to be licensed by default, they are carved out of the definition of marketing affiliate. I would need to adjust that carve out in order to ensure that revenue sharers who do not operate in the Commonwealth on a regular basis are registered by default. That is not a tweak. We've had to do enough work on the scope of the carve outs and their interplay that I would not be comfortable making that tweak on the fly in this meeting.
Well, let's think about that. I'm going to offer a little bit of a counter argument to the tweet. Because first off, is that how it works traditionally with our vendor situation? Director Lilios, if you're not expected licensure and regular, does it come down to the non-gaming and then it's your judgment to bring it up? Is that how it works?
On the casino side, that is how it works. It comes. It's a little bit different on the sports wagering side. If the vendor is directly related to sports wagering and is regularly doing business, they have to get licensed. Otherwise, the operator has to disclose these non-sports wagering vendors, and the IEB looks at them with criteria in mind from the regulation and determines who has to be registered. So it's not automatic.
It's not automatic. Okay, I just want to, I feel obligated to make this counter argument. This revenue share that I feel I learned over the course of this last week, revenue share compensation model is it's more likely to be exercised by less experienced marketing affiliates or those who are new to the market. And I know that is perhaps some of the risks that Commissioner O'Brien is thinking about. I also am thinking about those who are new to the space that we want to make sure we don't inadvertently create unfair barriers. And I am thinking of our obligation as a commission under our statement of purpose in terms of equity and inclusion. This is a licensing issue, and I don't want to unnecessarily create an additional barrier that could impact communities of color, individuals of color. And what I'm hearing is that if they're a one-off, I don't want to necessarily make them have to jump through licensure hoops unfairly if this is how we treat other vendors. Because that one-off experience may allow them to get into the market so that they can start building a business in this sports wagering industry. And so I'm comfortable with the risk-based analysis as long as, our operators give us the notice and Director Lilios and team looks at it, they can decide if it goes up. And if I understand correctly, that's right now the way the reg is structured really reflects how we have been functioning with vendors across the board in the gaming world. And we have the structure for the sports wagering. We heard from at the round table that these smaller businesses need this choice on revenue. I am absolutely cognizant of the risks that Commissioner O'Brien is thinking, but I also want to make sure we don't shut down opportunity for valid emerging companies, particularly those that might be owned by minorities, women, LGBTQ. And so I'm just going to state that I am comfortable with the risk that we're taking here. That's my opinion. That's my position. And I say that intentionally because that's what we have adopted in our inclusion, that we've got to think about inadvertent impacts. So I'll take any counter arguments on that.
I stated why I would want them to be default into registrants. And while we have a very promising company that was before us on Monday, I think to say that you're necessarily going to get DEI out of smaller businesses, I don't necessarily think that that follows. While I hear you and I embrace the concept, I'm not so sure empirically it's justified by what we've seen. I would rather have the protections in the market, which is also part of the mission statement of protecting the risk and the harm. I would rather have it be default to registrant myself, to keep out fly-by-nights. But that's my perspective on that. I fully hear and appreciate what you're saying. I'm just not so sure that having them default to registrant would really be that much of an impediment on that point.
Okay. So Paul, I understand that if you were to tweak it to favor Commissioner O'Brien's position, you would need a little bit of time with that language. Commissioners, you've heard from both me and Commissioner O'Brien. Commissioner Skinner, are you reading it?
I am, thank you. I think your considerations are necessary. I think you're absolutely right. We do not want to impose barriers to small businesses, minority businesses, WEBE, excuse me. I'm wondering, though, just to try to, meet in the middle in another way that hopefully might be less onerous for these one-offs. Could we somehow take advantage of an exemption process similar to what's offered on the gaming side? So, where there are vendors who might not be engaging in this activity regularly, we could have the default, well, let me back up. We could have the default be that all revenue share vendors are required to register, to be licensed. However, offer the opportunity for them to apply for an exemption. It's different from a waiver, but it kind of has the same effect. But they would be given the opportunity, and we can write this in the regs, hopefully, if we agree, to apply for an exemption from the license requirement. And I guess I'm posing that question to Director Lilios.
There are some exemptions that you do have they're called exceptions in this reg. They are listed on, I've got it on page 5. I printed it out, but there are some exceptions, and some of them are just simply automatic. They don't come in as applications for an exemption or requests for an exemption. I think.
If I may.
Yeah.
I don't mean to interrupt Director Lilios, but there is a petition process for entities that are vendors to be waived down to either registrants or non-sports wagering vendors, and for registrants to be waived down to non-sports wagering vendors. It's on page 285 of your packet. The paragraph is labeled B. We've adapted a version of that for marketing affiliates in general, and we could adapt a version of that for revenue sharing advertisers as well, as long as we're told what reasons would be permissible for them to waive down.
Right, the idea being that if
My
they're
position is I'm good with what was proposed. I'm sticking to that, but if we want to, devise a special, this is just again through April 14th. Obviously, this is going to go into the reg, and it's going to be, we'll have to amend it after April 14th.
Yeah. I mean, I like the idea that Commissioner Skinner put forward, because for me, it addresses the idea that these people will have to come to us in some capacity. And if the capacity is asking for the exemption on the rationale that I'm only doing this one time, So I shouldn't have to do this right now. It allows them entree into the market. If they come back again, obviously they're not in a position to ask for that anymore, and they would be coming back in a different status. So it would assuage my concern about not having people come in and out without any kind of accountability or.
But I do understand. I do understand. Am I wrong? I want to make sure that we're not saying there's no accountability. Director Lilios, if there's a one-time affiliate, the operator must disclose it, correct?
Yes, but by the time the IEB could review it to determine whether to require licensure, their service may have been provided.
And that's what happens with our vendors now.
That's correct.
Yeah.
And by the way,
advertising vendors differently.
Excuse me 1 second, Commissioner O'Brien. Our reg in advertising holds the operator responsible for all the content and the activity on restricted advertising and branding. So if that one-off, I guess I'm just saying that's all. I understand we all want to hear each other. I'm trying to get through the regs with some reasonable assessment on risk and fairness. And Commissioner O'Brien, I am hearing you, and I know that I understand your sense of worry, but I just want to make sure we're being practical at the same time. So.
So am I, Madam Chair.
Okay, thank you. So, we can amend this, but we're going to have to revisit it. And I am quite aware of the fact that we do have some deadlines here.
Right.
So Commissioner O'Brien, that's where I'm being practical. Commissioner Maynard.
No, it's fine. I'm enjoying the conversation. So I have a practical question to follow up on Commissioner O'Brien's question and your question. If someone is captured in that initial disclosure, would we review if they came a second time? Because I think that's important to know. If we would review it a second time, then we may have solved for the problem of the fly-by-night that's trying to just do one-off, one-off, one-off.
Commissioner Director Lilios.
I mean, in the crush of business, it can be difficult to have a timely, review of that before it happens again, right? So it would be helpful to the IEB for you to be specific on what the criteria are for when somebody when somebody needs to get elevated to, or even register in the first instance, when that becomes a requirement, what would you like there? Because, if we have the term regularly in one part of the regulation, and to you, that means the second time they're not regular anymore, it would be helpful to have that, self-policing in the regulation. Because, we review it on the casino side, we review disbursement reports, and they are after the fact, right? It's what was dispersed. So we go back and we look at them and we try to determine what registrants. Now on the gaming side, all of the vendors must be either registered or licensed. That is not the case on the sports wagering side. So we review those disbursement reports largely to determine which of the registrants need to be elevated. Where's there a big dollar amount and we need to elevate them? So the fact that we're looking at it a little bit after the fact is fine. They're already, registered. We've already done some measure of invest on them, and the regulations call for that. I'm just,
Can I turn to Caitlin and Paul, please? Paul, I'm hearing that in order to address the issues, you would need more time. You would not be able to do that today, correct?
I think it would be best to take a little bit more time, yes.
So Caitlin, give me some ideas on how to get the work done that we need to get done, because the folks have asked for us to resolve this today. What's the best scenario?
Well, let me just ask, is there a hard stop at 3?
Yes, I know Commissioner Skinner has a very important meeting today.
Okay.
I do, but I can look into adjusting that meeting, and I'm happy to if availability permits.
But I'm not being fresh. It has to do with her high schoolers, so I'm very cognizant of that. So,
It sounds like Paul has something on that front too to say.
And Kay may not be available at 3. I will say that it may be possible for the commission to come to a consensus on how the reg should function in the absence of outside counsel, and then we can take that direction and bring you back a reg that implements it, which would give the regulated parties some understanding of what's going forward, but not require us to rewrite the reg on the line.
And I think there's also other sections of the reg, again, that we'd like to deal with today. So, or not today necessarily, but at the same time. So I don't know that there's, there's a way to do to update reach a consensus, update the reg, and have it ready for a vote for the commission today.
But if we adopt this right now, the system that's been proposed that reflects what's going on in licensing now and IEB now, that would be in place in alignment with what our consensus was, because we had a consensus, with we'll entertain revenue share entities if there's a heightened licensure.
With respectfully, Madam Chair, on the understanding that they would be at a minimum registered. And so, to be blunt, my consensus was based on that understanding.
Can we add a section then of VI, or whatever it is, Paul, notwithstanding this, should a sports wagering vendor or third party operator, whatever the entity's definition is, not be required to license because of the lack of regularity, they must be a registered. Could we just at least do that for now? Is there something that's just straightforward, notwithstanding everything else in this reg, have a real straightforward carve out for them? I'm looking for anything straightforward right now. Thanks, Paul. I can fully disclose that I had the benefit of having Paul be an intern when I worked in the governor's legal office, and he was the guy I turned to for just these kinds of things. So here we are again. So thank you, Paul.
Madam Chair, what page are you looking at in the packet? Just trying to follow along here and make sure.
282, I think.
282. I'm just wondering if we can do a simple carve out, and then we can return to this reg with the additional issues. Let's look for something that will get people comfortable, unless I've got 4 of the commissioners who are fine with how it is.
Can I clarify, Madam Chair? I'm comfortable with the language as it's written right now, the regularly language. I just don't really like to leave a commissioner out. I've been there, so it's just at the outset, I want to make sure that we all have our concerns addressed. And so, I offered up that suggestion sort of in the spirit of compromise. And so, but I also recognize the fact that we will be returning to these regulations when it's time to do the final promulgation. So if we cannot, and I really hate that, I don't want to put Paul on the spot. He's said already that he'd like some, and I'm not suggesting that you are doing that, Madam Chair, but he's already indicated that he'd like some additional time to think this, any changes through. And so I think we should respect that. Again, with the understanding that we'll have another opportunity to come back to these before we take a vote to promulgate them and file them as final.
Commissioner Skinner, so is your position right now, rather than having Paul do some kind of a quick carve out, that you prefer that we that you are okay with the language? Or what is your suggestion? I understand, we love when it's 5-0, and we are so often, and I don't think Commissioner O'Brien and I are very, very different. I think I'm just trying to be, get this through. If we had days and days, we could probably get it right down. So it's not as though I understand her position, and it's certainly not to be disrespectful to her position. But I guess I do have, as my role of chair, I am trying to figure out our majority position so that we can move forward. So what is your position, Commissioner Skinner?
I'm comfortable moving forward with the language as written. I appreciate Paul, his request to kind of have more time. None of us work well under pressure and short notice. So
if there is someone who can do it, it's Paul Commoners.
I'm not taking anything away from him, but just, again, my position is that I'm good to move forward with the regulations as they're written today.
Okay.
Madam Chair, Commissioner Skinner, what I would actually like to, first of all, Madam Chair, you are very kind. Second of all, what I would actually like to ask for is a 5-minute break to see if I can write you that very simple carve out. If I can get it done in 5 minutes, then I'll put it before the commission. And if I can't, you'll have that information.
And then that would address Commissioner O'Brien. And again, this would come back to us another time. With that said too, Caitlin is also would like us to look at the other changes as well on this. So why don't we do that 5-minute break? And Paul, it's 2:31. I'm not hearing a hard 3, or somebody have a hard 3.
Well,
Dinner still has it. Yeah.
You do, Commissioner Hill.
I don't have a hard, I'm gonna have a hard 3 at leaving the office. I'll be on my phone from that point on.
Let's work toward 3. Okay, Paul, I'll give you 5 minutes.
Thank you, Madam Chair.
Paul's excused. Everybody else gonna take a break as well. Thank you so much.
would have put on a matching tie if I had known about Problem Gambling Awareness Month.
Okay, Nils, I think we can take down. But I see Paul is back. Okay. Paul, I don't know if you had a chance to address the issue. We also, you know, I will entertain any motions that are available always on these matters. So,
Madam Chair, I very much want to.
I guess I do need to take a roll.
Oh, of course.
Brian,
I am here.
Commissioner Hill,
I'm here.
Commissioner Skinner,
I'm here.
Commissioner Maynard.
I'm here.
All right, now Paul, thank you.
Madam Chair, I very much want to avoid setting unrealistic expectations for the future. But I think that we have language here that will require all revenue sharers to be registered, that will buy us some time to take a more holistic look at their treatment and perhaps adapt and consider a petitioning provision. If I may share my screen.
That'd be great. Thanks.
All right, so we're now into two colors of highlighting, for which I apologize, but don't see a way around. So the changes that I'm currently proposing that are not reflected in your packet are in blue highlighting. What we've done is take the word regularly out of the definition of revenue sharing advertiser. So revenue sharing advertiser is now anyone who promotes sports wagering to patrons, anyone who recruits other advertisers, and who does so, pardon me, I still need to take this language out, and anyone who does so in exchange for a percentage of net gaming revenue earned from those patrons. Where we've moved the word regularly is into subparagraph 2, which sets out the licensing standards for those entities. So now the requirement that no person operate as a revenue sharing advertiser unless licensed only covers those who operate as a revenue sharing advertiser regularly. And there's another catch-all clause here that says that no revenue sharing advertiser may conduct business with a sports wagering operator otherwise unless registered.
Paul, thank you. I'm going to digest it, but the other commissioners need to too.
Yeah, I guess, Paul, my only question on one is, should it say sports wagering revenue or is gaming cover it?
You were right, it should say sports wagering. I'm going to say,
Otherwise, I think it addresses what I was concerned about.
I think you're correct, Commissioner O'Brien. Thank you.
Paul, could you just move your,
yep.
I'm just going to. Commissioner Skinner? How are you feeling about it?
I'm good with the language.
Okay, we can take the language down now so we can see each other. Okay, so with that language, and Paul, I have great faith in you. Thank you so much. All right, now let's and no assumptions made for the future, commissioners. We want to make sure that Paul feels and the entire legal team feels comfortable. I have great faith. Okay, so now, if we are to accept that revenue sharing basis, before we turn, I'm going to turn first to Caitlin, before we turn to the vendor regulation as a whole, do we need to go back to our advertising reg and move on the other half of our discussion on rev share if we assume this change is in place? Or does it, or should we do the first and adopt the vendor language first?
I think it might be easiest, since we're sort of, our minds are in the vendor reg, to finish the vendor reg. There's not much more past this. Vote on the vendor reg and
All
then
right.
move back to the waiver.
Okay, so everybody keep the waiver piece in mind with that language. Are we satisfied? I think it reflects the intentions that we wanted. Okay, now, moving on then.
Yes, I think Paul will walk through the rest of the proposed amendments to the vendor reg.
Commissioners, I'm going to recommend you start on page 281.
Yeah.
So this extended.
Excuse me, Madam Chair. Paul, what number did you say?
Pardon me, 281.
Thank you.
So as I said earlier, there is no other entity that is registered by default under our vendor regulation. So the language, the red line that you're seeing here does two things. It defines the third-party marketing and advertising entities that need to be registered by default, and it sets out the requirement that they be registered by default. And then it creates the infrastructure for them to either be upgraded to vendors if their contract is of a size or of a nature or otherwise has potential implications for consumer protection that would call for that, and also enables them to be downgraded to non-sports wagering vendors if they upon a petition. So I'll start with the definition, which begins in paragraph D1, Roman numeral 1. And I'll take you through all of the line items and carve outs to explain what work each piece is doing. So the first carve out is who is not a sports wagering subcontractor. If we simply defined these entities based on the kinds of services that they were providing, we would sweep in sports wagering subcontractors, and on discussion with the IEB and licensing, their preference is for subcontractors who are marketing affiliates to be captured through their normal process. We do capture entities that hire marketing affiliates as subcontractors. So we will continue to register and have insight into those entities, and particular subcontractors can always be upgraded to registrants. Subparagraph B in yellow highlighting is the carve out for revenue sharing advertisers. Subparagraph C and D should actually be merged. I apologize for the error in the copy before you, but there's the semicolon, and the semicolon there should be deleted. The or should be reinserted, and the paragraph should be merged. This is what we just saw in the definition of revenue sharing advertisers. This is the meat of the definition. A marketing or advertising affiliate is an entity that either promotes sports wagering to patrons or recruits others who do the same on a regular basis. And here again, regularly is for conformity with our general definition of what it means to be a sports wagering vendor. Subparagraph E, who does not otherwise provide goods, software, or services which directly relate to sports wagering operations, is to ensure that someone who would otherwise be a sports wagering vendor is not downgraded to a registrant by virtue of the fact that they provide marketing services. And the final subparagraph F, who is not an entity described in, I'm not going to go through that entire designation, but who's not a television, radio, newspaper, internet, or other media entity, is meant to carry through an exception to general registration requirements that appears further down in the reg. The main idea here is to distinguish entities that really carry advertisements from entities that really generate advertisements. And again, the IEB will see disbursements and disclosure. It will see disbursements and disclosures relating to all of these media entities. And if the relationship with one of them is such that that entity should be registered, the IEB and licensing can always require that. So that's the definition of third-party marketing or advertising entity. That seems like a good moment to pause and invite any questions.
Commissioners? I'm not seeing anybody leaning in, Paul, so continue, please.
Paragraph 2 contains the requirement that third-party marketing and advertising entities be registered as sports wagering registrants. Paragraph 3 paragraph 3 and 4 together permit licensing in the Bureau to upgrade them to sports wagering vendors. The list of factors that they may consider, I hasten to add, without limitation, referred to at the end of paragraph 4, is the same list of factors set out for them to consider when deciding whether to upgrade a non-sports wagering vendor to a registrant. The final paragraph the final paragraph 5 sets out a notice and, in effect, appeal period for the Bureau and licensing to notify any registrant who needs to be licensed as a vendor instead to be so licensed. And this is consistent with the process set out for non-sports wagering vendors to be set up as registrants. And then finally, I believe this will appear as subparagraph 6, but track changes gets a little bit wonky with paragraph headings, for which I apologize. Is the petition process for an entity to be downgraded from a registrant to a non-sports wagering vendor, and this is based on a similar provision that allows vendors that must be licensed to petition to be downgraded to registrants or non-sports wagering vendors. And that is the sum total of how we handle third-party advertising or marketing affiliates in this regulation, and that seems like another good moment to pause.
Questions, comments? Okay, I'm not hearing anything from the commissioners, team members, any concerns? Okay.
It's not a concern, just a thank you. I mean, I know that this has been a slog, so I just wanted to say thanks. Today, just being part of it for the work that you guys have been doing to wordsmith this.
I want to be very clear that this has been a complete team effort with the IEB licensing and with legal, and we're very grateful for the many meetings that everyone has sat in on hammering this out together.
Excellent, excellent. Okay.
Not least to mention the commissioners. The last set of changes that I'll draw your attention to begin on page 298 and run through to page 299. So as we've said a few times today, 234 was one of the first regulations that the commission adopted, which meant that at the time that we adopted it, at the time the commission adopted it, the conversations about discipline had not taken place, and there certainly was no discipline regulation for sports wagering. So 234 originally had a custom disciplinary provision. Since then, the commission has adopted 232, the umbrella discipline reg. And so we propose striking the custom disciplinary provision, which is in at least one very small way actually narrower than the umbrella disciplinary provision, and simply replacing it with what functions as a cross-reference to 232. And that's what the changes to sections 234.11 and 234.12 accomplish.
questions on that? Again, sort of the benefit of evolution and thinking about these matters over time. So there we go. All right. That's it, right, Paul?
That's it, Madam Chair.
Okay. So, commissioners, we started out with the initial motion that Commissioner Skinner started with yesterday. We got through on the CPA piece. Now I think we recognize the intersectionality between revenue share piece under the advertising and this regulation. I think what our legal team is recommending that we move with respect to this regulation first with the changes that we've discussed today. Are people in agreement with that? First, legal, is that how you like to see it that way, right, Caitlin?
That would be wonderful. Thank you.
Okay, excellent. Commissioner Skinner, may I turn to you?
Absolutely. I move that the commission approve the small business impact statement and the draft 205 CMR 234 as included in the commissioner's packet and discussed here today.
Second.
Okay. Any further discussion? Okay. Commissioner Bryan,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
and Commissioner May. Okay, so we took care of that with my vote, yes, 5-0.
Okay, part
Right.
2.
Yes.
I move that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that staff shall be authorized to modify chapter or section numbers or titles to file additional regulation sections as reserved, or to make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Thank you. Any questions or edits on that? Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes, 5-0. Now we go back to the advertising regulation. We separated out the concepts of CPA and revenue share. Commissioner Skinner, with today's discussion.
Sorry, jumping ahead. I'm anxious to get through this one finally.
Yes, me too, and I'm anxious to hear it. Thank you.
I move that in accordance with 205 CMR 202.023, the commission issue a waiver to all licensed sports wagering operators from 205 CMR 256.013 that allows revenue sharing agreements until April 14, 2023, as granting the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of General Laws, Chapter 23N.
Second.
Thank you, Commissioner Hill. Any edits or discussion, Commissioner O'Brien?
Nay.
Okay, Commissioner, I thought you were going to weigh in on discussion. I'm sorry.
I feel like I've
You're all
participated
set.
a lot today. I think I made myself clear. I don't think this is the time or the forum to do it in, but that's the short and sweet on that. And
Okay.
I will be nay.
Okay, and I assume there's no other discussion or edits from anyone else. So, all right, so nay is recorded for Commissioner O'Brien. Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. So 4 yays and 1 nay. And thank you. I think that everybody worked to hear each other, and I appreciate that very much and appreciate everyone's patience. And I want to extend my thanks to Paul Commoners. Again, it's great to see everybody at work, and sometimes it is a little bit on the spot, but there we go. You did a great job, so thank you, Paul. Is there any other business for today? Commissioners?
The only thing I just wanted to bring up was some of the ads that I've been seeing. Bruce has been very responsive when I call and put queries out. And FanDuel was very responsive in terms of, I saw an ad that referenced being able to load with a credit or debit card in a graphic for Massachusetts. They pulled it down, they changed it. I do want that to be brought up at some point. The revised ad mentions a prepaid FanDuel card, which she's looking into for me, but it's something I did want to put out there for broader discussion, just to make sure that maybe some of the fixes aren't creating other credit card or one step away credit card situations as we're heading toward the launch next week.
Thank you for that. Which reminds me too, we should also just make sure that Executive Director Wells updates us on the universal wallet issues that have come up.
Correct.
So
That was that,
correct.
and as when Bruce responded to me, that was a question that I had. I think it circles back into the universal wallet question.
I have anecdotally heard that there was also a situation where the kiosks at one of the entities, and I won't say what it is, didn't have security around it. I don't know if we affirmatively stated that we require security at each kiosk section. I think there was an expectation, Commissioner O'Brien. I think
Well, the reg describes that there has to be, if it's not going to be closed off from under 21, that they basically have to get approval from IEB on the setup. It's the whole reason PPC decided not to put kiosks in the horse racing area, because of the 18 and 21 disconnect. So,
right. So that would be another area for, that's again, where we are underway at the retail and as we move towards March 10th. So it's quite right to bring up the ads. It's also for us, those extra eyes, everyone's watching those advertisements. Thank you, Commissioner O'Brien, for that. And then I'll just circle back and make sure in terms of the kiosks, if our folks on the floor can just be monitoring that and make sure for compliance at this time. Anything else? All right, I'll take a motion to adjourn.
so moved.
Second.
Commissioner O'Brien.
Aye.
Commissioner, oh,
Hi.
thank you for your shirts, both of you, very much. Thank you. Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. 5-0, everyone. Thanks. Excellent work today. The entire team, we appreciate it. And I think we got to a very good spot. And Commissioner Skinner, again, my gratitude.